Howdy, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, Montgomery County, Houston, this whole region of Texas. And so today is going to be a continuation of our evidence lecture series, a short lecture, so stay tuned. We're going to be discussing Rule 105 today of the Texas Rules of Evidence. Rule 105 is talking about limiting instructions, how the court can limit evidence admissibility for specific purposes. For example, I wanted to talk about one case in particular, Logan versus State, which is 71 Southwest 3rd, 865 out of Fort Worth in 2002. And this was a case of an assault, family violence, and the defense attorney wanted to use an affidavit of non-prosecution and admit that into evidence. Well, the state objected, and the judge ruled that it was not relevant and excluded it from evidence. They appealed that decision. The defendant was convicted. They appealed the decision, and the Court of Appeals said, well, maybe it was error, but you didn't ask for the evidence to be offered for the limited scope of impeachment. Okay, impeachment being saying to the jury, we think this witness is lying, here's why. Okay, impeachment evidence, or something that gets offered as impeachment evidence, is not what they would call substantive evidence. So you can't argue that, well, this is what she said before, so that's the truth, right? But you can argue, she said something here, it's different from what she said now, that person's a liar, right? There's a very slight difference there, and that's what the rules in Rule 105 says. And the appellate case law on this is that if you don't ask, judge, okay, I see you've excluded this evidence, I wanted to get into it, can I please offer it again for the limited purpose of impeachment? Now, if the judge had overruled that as well, then we have a pretty broad cross-examination rules here in Texas, and the Court of Appeals in Fort Worth probably would have upheld that. And they said as much in their opinion that they couldn't even consider that because it was not requested by defense counsel. So one other note here on limiting instructions is, let's say the limiting instruction is about a prior conviction. Well, a prior conviction can typically not be offered during the guilt-innocence phase unless there is some reason either outlined under Rule 404B or that you can come up with under 404B in order to get that evidence in front of the jury. But even if there's evidence of some other bad act, some other crime offered in front of the jury, you should always ask for, in every jury charge with that kind of information brought during the trial, the jury charge should include this limiting instruction that says, okay, members of the jury, if you find that this bad act occurred beyond a reasonable doubt, then and only then may you use it for the limited purpose of whatever that purpose was. Was it to show motive, intent, opportunity, common scheme, plan, or maybe it was just as impeachment evidence. And so as the defense attorney, you need to be watching that jury charge to make sure that language is in there. If there's a prosecutor out there watching this, you need to watch it too, because you don't want to get your case reversed on appeal because of the lack of a jury charge instruction. So thanks, everybody. That was Rule 105. It is the rule related to limiting instructions and pretty straightforward. Hope you have a great day.